I think in December, with an event on John F. Kennedy and the emerging war in Vietnam. We have a book event by two Miller Center faculty members on Richard Nixon and arms control, particularly with Russia, not irrelevant in the current environment. We have a book that Barbara Perry and Mike Nelson have co-edited based on the oral history project for the Bush 43 administration, a new understanding of that administration, a series of essays on everything from 9/11 to the financial crisis, bookending that two-term administration. And then in addition to that, we have three big new research undertakings at the Miller Center, each of which has a signature program this fall. Our project on democracy and capitalism has an event later this month on how the world got rich. This is a project that Bob Brunner helped start here at the Miller Center and that has brought together a number of scholars at the center as well as scholars from across the university. We've had a project on the war on Ukraine. We did a few events in the spring as webinars that you may recall. That is something we call the War Room. Once a week, including this morning at 9 o'clock, a series of scholars from across the university get together on Zoom and discuss the ongoing war in Ukraine and sponsor a series of events and other research activities based on that weekly conversation. And this year, we're going to have a conference on that in early November that will feature three panels here in the forum room, a democracy dialogue in the rotunda, exploring the war in Ukraine in its full geopolitical context. We're really excited about that. And then finally, our other big research undertaking, which we are increasingly taking UVA-wide, is a new health policy initiative that is co-headed by Mimi Riley and Guillen McKee here at the Miller Center, focusing on health policy in all its dimensions. And today's event is the first 2022-2023 undertaking under that banner, looking at reproductive health in light of the Dobbs decision. The new conventional wisdom is that the Supreme Court's decision on Dobbs has completely upended politics in America. By overturning Roe v. Wade, it has overturned a sort of relatively stable political contest in the United States and turned it into a more dynamic and fluid one. There are few issues that are as polarizing as abortion. I'm sure we could name one or two, but abortion remains one of the most polarizing issues in America. And yet, a majority of Americans don't want to be polarized on the issue. They are uncomfortable with abortion, but they're also uncomfortable with a complete ban on abortion. Our purpose with today's event is not to discuss either the politics or the moral foundations of that debate, but instead to look at the foundational issues that the Dobbs decision tried to address, and try to present a foundational mapping of the decision, its legal implications and its policy implications, particularly for reproductive health issues. I'd be curious to see a show of hands in this room for how many people have read the entire 200+ page decision and the responses. I see one hand in the back, one hand in the front. I think that that's actually quite indicative of where the American public is. And I would raise my hand for those who have not read the complete decision, though I have read pieces of it. So today's event is targeted for those of us who have not done so. Its straightforward goal is to review the history, substance, and implications of the decision in both law and policy. Not to debate, but to lay a foundation for informed discussion and debate. I think these are vital issues that all Americans are going to have to grapple with in the coming years, not just in the midterm elections, but beyond. So for today's conversation, I'm going to turn it over to Mimi Riley, the co-director of the Health Policy Initiative here, who will lead the discussion. Mimi is our Dorothy Compton Professor of Government at the Miller Center. She's also a professor at the law school. She has appointments at the School of Medicine and the Batten School of Leadership and Public Policy. So if our goal at the Miller Center is to often be a place where people can come together across the university, Mimi showing up here every day does that in and of itself. She's an expert in particular on bioethics, food and drug regulation, and animal rights law. In addition to co-directing the Health Policy Initiative, she helps lead our democracy and capitalism work as well. Nima will introduce the other panelists and lead us through a discussion of what Dobbs decided and what it did not. So with that, Mimi and our other panelists, thank you. And I hand it over to you.
Thanks, Phil. So to help us understand what's in, and I actually brought it for you all, because sometimes visual aids are better than, help us understand what's in here, but perhaps at least as importantly, how we got here and some of the implications going forward. I have two of my favorite colleagues here. Naomi Kahn is an expert in family law, trust and estates, feminist jurisprudence, reproductive technology, and aging in the law. Prior to joining the University of Virginia faculty in 2020, and for a while we just knew each other online, actually. Yeah. She taught at George Washington Law School, where she twice served as associate dean. She's the co-director of UVA's Law's Family Law Center. She's the co-author of case books in both family law, trust and estates. She has written numerous articles exploring the intersections among family law, trust and estates, feminist theory, as well as essays concerning connections between gender and international law. She spent some time in Kinshasa. I didn't have time to add all that piece in here. In addition, she's the author or editor of books written for both academic and trade publishers. Her work has been featured in major media outlets, including the New York Times and the Wall Street Journal. She currently writes posts on gender equity for Forbes, and I really recommend that you take a look at those. Kahn is a recipient of numerous awards and appointments. I'll highlight just a few. In 2017, she won the Harry Krauss Lifetime Achievement in Family Law Award from the University of Illinois College of Law. She's a member of the American Law Institute, served as a reporter for 2 drafting committees on the Uniform Law Commission, and is an elected fellow of the American College of Trust and Estate Counsel. Thanks for being here, Naomi.
My pleasure. Thank you.
Barbara Perry is probably a familiar face for those of you who come here often, or at least came here often before 2020. She's the Gerald L. Beliles Professor and Director of Presidential Studies at the University of Virginia's Miller Center, where she co-directs the Presidential Oral History Program. She has authored or edited 16 books on presidents, first ladies, the Kennedy family, the Supreme Court, and civil rights and civil liberties. She's also a non-resident fellow at the University of Louisville's McConnell Center. Perry has conducted more than 120 interviews for the George H.W. Bush, the George W. Bush, and the Barack Obama Presidential Oral History Projects, participated in the Bill Clinton interviews, directed the Edward Kennedy Oral History Project, and co-directs the Hillary Rodham Clinton Oral History Project. She served as a United States Supreme Court Fellow, where among other duties, she provided research for Justice William Rehnquist's speeches, and she won the Tom C. Clark Award for the Outstanding Supreme Court Fellow. She has worked for both Republican and Democratic members of the Senate. She is a frequent media commentator for major national and international news sources, and in addition to the American presidency, and we include first ladies in that, her research, writing, and commentary have covered the U.S. Supreme Court, particularly presidential appointments, as well as civil rights and civil liberties. And so what you can see, thank you for being here, Barbara. We have 2 panelists who are going to give us a mixture of views, political, cultural, social, legal, as we try and grapple and understand what this case means, how we got here, and where we're going. So thank you to you both. Now, to understand the present, we have to go pretty far back. And we're going to spend a fair amount of time in the beginning going through some of the history here. And I think to understand Dobbs, we have to go all the way back to Griswold. So Griswold v. Connecticut v. Griswold, decided in 1965. Naomi, could you tell us more about that case and how it lays a foundation here?
Sure. Griswold versus Connecticut is considered to be one of the modern cases that formed the modern birth of privacy. It was a as you said, 1965 Supreme Court opinion. It was a 7-2 decision, and the Connecticut law at issue dealt with contraceptive use by married couples. Married couples, until 1965, it was perfectly legal for a state to ban married couples from using contraception. That's what the Connecticut law was about. The Supreme Court in 1965, per 7-2, struck down the law, saying that it invaded the marital, I don't know if you want to say anything about the author of the opinion, it invaded the bedroom marital privacy, and the law could not stand. So it extended constitutional protection to marital privacy, including the right to use contraception, per Justice Douglas. So
I'll just add to that. My favorite part of that opinion by Justice Douglas, if you know his biography, was, if I'm correct in saying, was married 4 times.
yeah,
He asked, how would the state enforce that law? And he literally said, would police officers examine bedrooms or other elements of a household to tell, as he said, find telltale signs of the use of contraception? So good question on his part.
right. For someone who had been married multiple times by that point, it was very concerned about the privacy of the marital bedroom.
Indeed.
But he based the opinion on penumbras of various amendments to the Constitution. And so when you hear about penumbras, Justice Douglas in 1965 talked about those penumbras, that all of the amendments had taken together created these penumbras to protect this right of marital privacy that included the right to use contraception.
And so that takes us, I should be able to do the math, 8 years later, we start approaching Roe.
Right.
And I'm not quite sure how to do this. Should we talk about what Roe did first and then go to how we got there?
Do you want to do Eisenstadt just briefly?
We should do Eisenstadt. Let's add Eisenstadt and then go for it. Because
Eisenstadt, yes. Eisenstadt decided the year before Roe, so 1972, 7 years after. So if Griswold establishes the right to marital privacy, Eisenstadt establishes the right of non-married people to use contraception. So up until that point, and this was a Massachusetts law, and I have friends who were at BU at the time that Beard, the ultimate defendant in the case, threw out packages of vaginal foam to make sure that he was convicted under this Massachusetts law, which prohibited the use of contraception, prescribing of contraception to unmarried people. And so the court extended whatever the rights of married people to use contraceptions, Justice Brennan, those rights extend to unmarried people, is what the court said in 1972. So that's the year before Roe is decided, although Roe is already pending before the Supreme Court at that point.
So we have a growing notion of privacy, and we move into Roe. How is the court at this point, Barbara? Right. Well, we talked about this in our pre-panel discussion, but what I always like to point out is some of you might know John Jeffries, who was the dean of the law school here, and he wrote on Justice Powell, who was his mentor. He served as a clerk for Justice Powell. When Justice Powell was nominated to the Supreme Court by Richard Nixon in 1971, and Justice Powell, first family of Virginia, and very much a part of the Richmond social elite, had been the head of the ABA, and lovely man. And there's no question about abortion. This is 1971, so just 2 years before Roe, and as Naomi says, Roe is coming along. It's down in the states. It's coming along, but no one asks a question of Justice Powell in 1971 at his confirmation hearings in the Senate about abortion. What is your view on abortion? Now, why is that? So I am not
as my two wonderful colleagues here are lawyers, I'm a political scientist by background and training. And as Bob O'Neill, the former president of UVA, used to say about my mentor here, Henry Abraham, Henry was a political scientist who studied the court. And Bob used to say, Henry has been engaged in the unlicensed practice of law for 50 years. So I'm maybe fall into that category. But if you remember leading up to the 70s in 1968, the issue for Richard Nixon running for president was his Southern strategy, which was about race and about civil rights and liberties as related to criminal rights and an attempt to overturn the liberal decisions in race and in civil rights and liberties from the Warren Court. So abortion wasn't on his agenda. So it really wasn't on his agenda for the 4 appointments he made to the US Supreme Court. So I think it's important to just, sort of recognize that. It's not really on the agenda for the next appointments after Nixon, and that is John Paul Stevens, appointed by Gerald Ford. Betty Ford wants to put a woman on the court. And so she tells her husband, be sure to include women on your list. She's also come out in favor of the Equal Rights Amendment. So it's sort of there in the background, but John Paul Stevens goes to the court. He ends up from being a moderate conservative, he becomes a reliable liberal vote on the court. So it's really not until Justice O'Connor's appointment in 1981, we'll go back and pick out Roe, but just to be aware of Justice O'Connor coming on as the first woman in 1981, she had been in the Senate. She was the first woman who became a majority leader of a Senate in a state. So she had been the majority leader of the state Senate in Arizona. And as such, she had voted to decriminalize abortion in Arizona. So when she got before the Senate Judiciary Committee, she ended up being unanimously approved by it and by the Senate. But we start to see what comes to light is that she apologizes. She says she erred in that vote when she was still back in the Arizona Senate. But she had support of Democrats and Republicans, including conservative Barry Goldwater from her state. But one person certainly who pops up against her is Jerry Falwell, he's leading the moral majority. And it's because of he believes her views on abortion. And I have to quote Barry Goldwater, who said, every right-thinking person should kick Jerry Falwell right in the ass. Vintage Barry Goldwater. Yeah. Now we turn back to Roe.
So Naomi, would you please set out for us the framework of Roe, what it's doing with abortion, how it relates to privacy, so we can then move on and see how it plays in with Casey.
Sure. In 1 minute or less on this famed opinion. Turns out I'm teaching an after Dobbs course at the law school that Mimi was kind enough to come to last night to discuss the implications. But it turns out the father of one of our colleagues was actually clerking for Justice Blackmun at the time that Roe was pending. And so, yeah. Anyway, I don't yet have any stories except that they very carefully guarded the opinion to make sure that no one had access to it other than the justice. So Justice Blackmun, a Nixon appointee, and who had Mayo Clinic experience. Mm-hmm. So physician, obviously not a physician, but a lawyer who had some experience with medical facility. And Justice Blackmun writes the opinion finding that there is a constitutional right to an abortion. And Roe sets out the trimester framework for when states can regulate abortion. So there's a constitutional protection. This is building on the right to privacy that's been established in Griswold and Eisenstadt. So the court finds that the right to an abortion comes within that constitutional protection that's afforded to individual autonomy and privacy. And he concludes that right to privacy is broad enough to encompass, this is quote, to encompass a woman's decision whether or not to terminate her pregnancy. The court also rejected arguments that a fetus is a person for purposes of the 14th Amendment and therefore endowed with a constitutionally protected right to life. Nonetheless, The court also determined that a woman's right to seek an abortion was not absolute and that her interests could be balanced against the state's interest in potential life. So that's where the trimester framework comes about. Should I continue with the trimester?
Briefly, and
Very,
then,
very
because I
briefly.
think we can't understand Casey unless you.
Okay, so first trimester, virtually no regulation by the state. Second trimester allowed regulations to protect very simple women's health. And the third, it allowed states to ban abortions so long as exceptions were made to protect the life and health of the mother. So that's the trimester framework. That's actually similar to existing Virginia law.
And we're seeing right around this time percolating in Congress, some of the debates between Buckley and Edward Kennedy on the National Commission of Bioethics and Fetal Research. And so some of this is percolating outside, but then it comes into the presidency. And so with how do things change as we move into the Reagan administration?
Right. Well, this is where we were sort of getting there with Justice O'Connor, right? So for Justice O'Connor's appointment in 1981, even though there were questions asked of her about abortion, which, by the way, she would not answer at her confirmation hearing, other than to say she erred in voting to decriminalize the procedure when she was in the Arizona Senate. But we know why she was appointed, because Ronald Reagan in the 1980 campaign was running a gender gap. What do we mean by that? It meant that the polls were showing prior to the election that he had greater support among men than he did women. So to try to bolster his support among women, he said that one of his first appointments to the U.S. Supreme Court would be the first woman. Now, this is despite the fact that Ronald Reagan was against affirmative action, for example, as a policy, but he made good on the promise in 1981. But it allows him then in his ultimate three other appointments, including promoting William Rehnquist, my former boss, up to Chief Justice in 1986, who is one of the dissenters in Roe, along with Justice Byron White. So it allows him to pick up the cultural change and the political change and turn that's happening with Jerry Falwell, as I pointed out in 1981. It allows him to pick up that restriction on abortion policy and start to put people on the court, including his last two appointments, again, promoting in 1986 when Chief Justice Berger left the court, promoting William Rehnquist from associate to Chief Justice, and then putting in Rehnquist associate position, Justice Scalia. And so the other area that I love to study as a Roman Catholic is Catholics on the Supreme Court. And many of you might know that going back into the era, particularly of immigration, justices had been placed on the court sometimes because of their religion. There was a Jewish seat that developed in 1916 with the appointment of the first Jewish justice, Louis Brandeis, my native Louisvillian. I like to claim him. And the Catholic seat developed. And how do you know that that's developing? Is that if a Catholic left the court, then the president would try to put a Catholic in that seat. But what I found fascinating as someone who studied religion and politics and religion and appointments on this issue of abortion, as you can imagine then, Roman Catholicism comes into the mix pretty heavily. So that by 1988, when you end up with Anthony Kennedy being the last Reagan appointee, and we won't even go into the Bork issue, but we can circle back to that if people would like to. But you end up with three Catholics at the same time on the bench when you know that presidents who had been putting one Catholic and one Jewish justice on during immigration periods to sort of reach out to new immigrants who tended to be Catholic or Jewish and say, I've put one of you on the bench. Now we know that that was no longer an issue, I think in part because when John Kennedy became the first Roman Catholic president, it sort of negated the need to reach out to that group. Now for another reason though, reaching out to that group because tendency was to be against expanding abortion rights. But fascinating to me, you end up in 88 with three justices who are Roman Catholics who represent three different points on the spectrum. So think of the political spectrum, left and right and center. In terms of their overall jurisprudence and ideology, Justice William Brennan, who had held the Catholic seat on the left, a mover and shaker in the Warren Court Revolution. On the far right, Justice Scalia, who had 9 children, by the way. And in the middle, Justice Kennedy, Anthony Kennedy. And it's not only that, generally speaking, in their jurisprudence and their ideology, that's where they tended to land on the political and jurisprudential spectrum. That's also where they landed on abortion. So that Justice Brennan had voted in Roe to expand abortion rights. Justice Scalia very much against expanding abortion rights, very much against abortion, and Justice Kennedy in the middle, which will take us to the Casey case.
Takes us almost 20 years after Roe. We're in 1992 to Casey. And so set the stage, Naomi, and tell us what happens here.
Well, before I even set the stage for Casey, you probably cannot see this, but this is a chart. It's actually from the New York Times, of increasing political partisanship. So just following up on what Barbara was talking about with respect to, before 1980, independents, Republicans, and Democrats are fairly similar. And this is a chart. Just looking at, should it be possible for a woman to obtain an abortion for any reason? There's actually, to the extent you can see it, pretty similar here. And there's then a great deal of divergence starting in the 90s until today, with Democrats and independents. It goes Democrats, independents, Republicans. Republicans are about where they were prior to 1980. Democrats have probably about twice higher, double the percentage of those in favor of for a woman being able to obtain an abortion. But there was a lot more uniformity at one point on this issue.
And less polarization.
Yes.
Yeah.
So
Casey.
1992, speaking of Justice O'Connor, a major abortion opinion written by a female justice. So Planned Parenthood of Southeastern Pennsylvania versus Casey concerned state level. So we're not concerned state level abortion restrictions in Pennsylvania. It almost overruled Roe. But according to Justice Blackmun's archives, Justice Kennedy switched his vote. And so the case was argued in April, and Chief Justice Rehnquist was at work on his majority ruling when Justice Kennedy sent a note to Justice Blackmun saying, "I need to see you as soon as you have a few moments. I want to tell you about a new development in Planned Parenthood versus Casey. It should come as welcome news." So that's from the justice. So it almost went the other way. But the way that it did go was Roe survived, but the court put new limits on the right to an abortion, and it was 5-4. It was Justice Kennedy's vote that switched that. And the court declared it got rid of the trimester framework that had been so carefully established by Justice Blackmun in Roe, declared that states could pass abortion restrictions so long as they don't pose an, quote, undue burden on the person who's pregnant, and there's a viability of the fetus standard. So the court actually upheld most of Pennsylvania's restrictions that were at issue, although including allowing for waiting periods and provisions for parental notification when minors sought abortions. It did toss out, per Justice O'Connor's eloquence in this opinion, on whether a woman had to inform her husband that she was seeking an abortion. And Justice O'Connor spends many pages talking about the impact of domestic violence on the abortion, on becoming pregnant, and then on the abortion decision, and says, essentially, we need to protect women facing domestic violence who fear telling their husbands that they want an abortion.
So we see O'Connor playing this role. In fact, we're going to, in the interest of time, have to speed through 30 years. But we see her play this role for quite a while, of bringing in the notion of a life lived by a woman. Barbara, take us through those 30 years and get us so we can, because it's already 11:30, so we better start talking about Dobbs.
Well, it is fascinating. Not that there needed to be a woman on the court to decide Roe. That was 9 men who decided Roe, and 7 of them supported expanding abortion rights. But it is interesting always to me, because because I also studied gender and appointments to the court and how that might have an impact on justices' decisions. And when I was a graduate student here, getting my doctorate in political science, I was able to interview most of the justices on the court in the 80s, including Justice O'Connor. And one of my stipulations in asking them for an interview, because as you can imagine, particularly at that time, they weren't that keen to give interviews, particularly to a lowly graduate student, but she was one of the first to say yes. Justice Brennan was, she was, in part because with Justice Brennan knew Henry Abraham. But on Justice Brennan's side, when we talked about his Roman Catholicism, he said, oh, I go to St. Matthew's Basilica every Saturday night for Mass. My wife and I go there. And he said, there are protesters there every week who don't like my decision in Roe. And they protest against me because they know at what time I come to Mass every Saturday night. And I said, well, how do you feel about that? And he smiled his Irish American leprechaunish smile. And he said, First Amendment, they have a right to be out there. And I went to his funeral in 1997 at St. Matthew's. And as they brought his coffin up the aisle, you could hear the protesters. So even unto death, they followed him. In Justice O'Connor's case, in talking to her, I said, I'm not going to be talking about your decisions, but I said, tell me about being a woman and your appointment as the first woman because of your being a woman. And she looked at me and she said, first of all, I said, what's the impact of being a woman? And she said, well, why do you think you're here? Woman graduate student. And then she said, look, we are all the sum total of our experiences. But she said, when I cross over the threshold of the door of this court every day, I try to put that behind me and I try to judge as a neutral arbiter of the law. And I believe that she tried to do that, but it is fascinating to me that she's still the only woman on the court in Casey. Justice Ginsburg isn't there yet. So what is happening then in the 90s? Obviously, we have the Rehnquist court. We have the Reagan court that is becoming more conservative. When I was here as a graduate student in the 80s, there was a book that was assigned to us about the Burger Court that was called The Burger Court, the counter-revolution that wasn't. And it was because the Nixon people thought that the people they put on the court would be able to overturn the Warren precedents. Typically, they did not. But it was the goal of the Reagan court to try to begin to change those things, and certainly in abortion. And then we know we speed up through the appointments of George, certainly H.W. Bush had Clarence Thomas as a conservative. He had thought Souter would be, but Souter ends up in the middle, right, with Justice O'Connor and Justice Kennedy and Casey. So he stakes out that part as well, that sort of middle ground, that moderate position to uphold the core of Roe, but change the dynamics from the trimester system to this undue burden test of Justice O'Connor. But certainly we know that we've got Clarence Thomas as an H.W. Bush appointee, and he converts back to Catholicism. He's raised a Baptist. He goes to a Catholic school as a grade schooler. And I don't know, how many of you know that he studied for the priesthood? He went to seminary and he studied for the priesthood, but he left it because he heard really racist comments after Martin Luther King was assassinated in 1968. It really put him off. He became an Episcopalian. And then in more recent years, he converted sort of back to Roman Catholicism. So that's his position there. He's hoping that others will join him in his conservative view on abortion rights and restricting them, if not removing them completely. Then George W. Bush has the opportunity to put two members on the court, including replacing Rehnquist when he dies in 2005, and Roberts becomes the Chief Justice. You might recall a name, Harriet Miers. Harriet Miers was W. Bush's White House counsel before she'd been his staff secretary, then had become his White House counsel. And she was thought as sort of an O'Connor figure, quite frankly, sort of a moderate Republican. And there was both the politics rose up, the Federalist Society came out against her. And finally, she asked the president to remove her name from consideration. And that's how Samuel Alito took another seat on the court. So two more Catholics, two more conservatives. And so by this time, unlike when I explained to you the Roman Catholics who had the three different positions on the spectrum, now Roman Catholicism as a religious affiliation becomes a shorthand for presidents who are looking for conservatives and looking for those who want to restrict abortion rights. And so you add that to the McConnell politics of not allowing Merrick Garland to get a hearing. And then you add to that the 3 Trump appointments, and we come to Dobbs.
So we come to this year.
We come to this year.
So Naomi, what does Dobbs do? Distill.
Still one, yes. Well, there's a 5-4 majority opinion to overrule Roe and Casey. So that's the part that I think we all know about. There's a 6-3 decision to uphold the Mississippi 15-week ban that was at issue in the case. And then the 3 dissenters file, Justices Breyer, Sotomayor, and Kagan, one of Justice Breyer's last opinions on the court, file a joint dissent. I don't know if we want to pause here, if you want to say anything about joint dissents. Okay. So the majority says our decision returns the issue, the majority, the 5-4 overruling, we return the issue of abortion to the states, and we thereby allow women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. Justice Alito, who wrote the majority opinion, says women are not without electoral or political power. It is noteworthy that the percentage of women who register to vote and cast ballots is consistently higher than the percentage of men who do so. This is the court speaking. And then, so as a result of this opinion, there's a new standard for reviewing abortion laws. Abortion is no longer kind of subject to searching review. It's now abortion laws by states are subject to review based on a rational basis on which the legislature could have thought that an abortion restriction could serve legitimate state interests. And he has a paragraph pointing out what legitimate state interests might actually be. Legitimate state interests include respect for and preservation of prenatal life at all stages of development, says the court. So legislation affecting abortion must be sustained if there's a rational basis for serving legitimate state interests, including respect for and preservation of prenatal life. Okay, so there are other reasons that he set out that I can also talk about, but there are then 3 concurrences. Justice Thomas calls for revisiting constitutional protection of all kinds of rights, all of the rights that we've been talking about, beginning with Griswold and Eisenstadt, the right to contraception, the right to marriage, and other intimate personal familial relations, based on his interpretation of the 14th Amendment to the Constitution. Justice Kavanaugh says what we're really doing here is we are trying to establish neutrality with respect to abortion by returning the issue to the states rather than by sitting here as the court. One interesting point from his concurrence is that he points out we will still protect the right to travel, which has certainly become an issue in a post-Dobbs America. Chief Justice Roberts does not, so both Justices Kavanaugh and Thomas join the opinion to create the 5-4. Chief Justice Roberts says, I would uphold the Mississippi state 15-week abortion ban, but I do not join the rest of the court in overruling Roe. He was concerned about precedent, stare decisis, and so that's the 6-3 in favor of Mississippi, the 5-4 in favor of overruling Roe and Casey. The dissent, the jointly written dissent, says for half a century, Roe and Casey have protected the liberty and equality of women. Roe held and Casey reaffirmed that the Constitution safeguards a woman's right to decide for herself whether to bear a child. The dissent says states can now always force a woman to give birth, but also says women of means will find ways to get an abortion, but those without resources will not. So that's the 3-person dissent. And that's
So I do, without saying you need to read all 200 pages, I do commend to you to read parts of this. It's the most emotional opinion I've read from the Supreme, on both sides, from the Supreme Court in a long time. And I think it reflects some of the agony that we're all feeling in a polarized America. So to take us to that, let's start. Naomi, tell us, because we talk too much, all of us.
we're professors.
Yes. So take us to where the states are now. And then what I'd love with Barbara, we're going to take us to where we are in the United States of America and trust and things. So.
Well, I'll also say, in returning the issue of abortion to the states, Justice Alito said, and we hope to get the Supreme Court out of these issues, out of kind of having to decide these abortion issues. But following the news, every day I read at least about 2 or 3 different state laws that are being challenged. Or where there have been opinions, both in, and there's state court and federal court cases that are certainly pending. But what we have as a result of Dobbs is a patchwork of state approaches to abortion. And there were 13 states that had trigger laws that were poised to, as soon as the Supreme Court essentially pulled the trigger, those laws would go into effect. The Washington Post estimates that as of today, about 1 of every 3 women in the U.S. has lost access to abortion. The state bans start at various places. Missouri bans abortion except in medical emergencies. Tennessee has an affirmative defense to performing an abortion for a physician who does that, and bans abortion at all stages of pregnancy except when necessary to protect the pregnant woman's death or serious risk of substantial and irreversible impairment of a bodily injury. Arkansas bans abortions except in life-threatening emergency, for example. At the same time, a number of states have moved to protect the right to abortion. So there are both bans in place and there are affirmative protections in place. I guess it was just yesterday that a Michigan judge ruled that the state's 1931 pre-Roe law banning abortions could not be enforced. That opinion will obviously be appealed, and Michigan is also considering whether to allow a referendum on the issue of abortion. So a lot going on in the states, a lot to follow. The map, which I can't show you because it's too small, but it has different states at different stages of, are they banning? Are they potentially considering banning? Are they potentially considering changing their abortion laws? Or are they moving to protect not just the right to abortion, but the rights of physicians who perform abortions on women from other states?
I think that's a beautiful summary. And I do suggest there are a number of media outlets that are running trackers right now. And so if you want to keep track on where we stand, it changes every day. Barbara, in terms of the implications and also how the court develops its jurisprudence, we've been talking about substantive due process, and there are a lot of implications that go beyond what we have just with Dobbs and abortion. Could you get us started? And then, Naomi, I'd love you to tag team into where we are in terms of other cases.
Sure. Well, another thing that I love to study about the court is where it falls in approval ratings. And it's the Gallup organization only started asking the question about the court in the 1970s. And why is that? Because we have approval ratings for presidents going back to the late 1930s, 1940s. Well, I think it was because they're not elected. So it didn't seem to matter so much what the approval rating was of the U.S. Supreme Court. But after my fellowship there in the mid-1990s, I wrote a book called The Priestly Tribe, the Supreme Court's Image in the American Mind. And the Priestly Tribe was a label given to judges by a lower federal court judge about their black robes. that he said they wear these black robes. Actually, he wanted them to get rid of wearing the black robes because he said it was sort of a false front. But he said, I know why they wear them, and we wear them. We wear them because we want to show that we have some sort of higher authority that we answer to, and that we have a uniformity. And we, as Justice Kennedy always says, we speak in a different language. And that worked. And when you sit in what has been called the marble temple that looks like a church or a basilica, and you have all of these different kinds of symbols around you. I mean, my favorite are under the flagpoles are turtles. Not real, but in bronze. And that's to show the slow pace of justice. And everybody knows about the blind, Lady Justice with the blindfold, justice is blind. So with all that symbolism around them, I was always, as someone who loves the court as an institution, was always thrilled to see that its approval ratings were ahead of most presidents. So usually in the 60s, ahead of most presidents. Another part of this is that they would tie themselves to the Constitution. And because the Constitution tended, at least up to now perhaps, to be revered in our country, that the fact that they tied themselves to it as an institution worked for them. So they would have these above 60% approval ratings. Presidents would be in the 30s or 40s, maybe in the 50s, and Congress, well, often in the teens for approval ratings, in part because they are mired in the muck and mire of politics, where the courts are just stood above that. So you might have been reading about where the court is currently. Before Dobbs, it had fallen into the 40% range on approval ratings. And something that really, I must say, terrified me for the institution was the leak of the opinion, the leak of the Alito opinion. Because while I had seen I would call it Roe v. Wade Day, I don't know what else to call it, but on the anniversary of Roe v. Wade, as politics and culture in this country changed, and you'd have people who wanted to limit or to totally abolish abortion rights would come to Washington in March. As Justice Brennan would have said, they had every perfect right to do. They'd start at the White House and they'd march to the court. The court would close down on that day to protect it, but they would often have our dinners, reunions for the Supreme Court fellows. And I can remember coming out at night after those dinners, I was telling Mimi this story, and I saw the police officers. The court has its own police force, and I saw them with flashlights looking under bushes, and I think they were looking for bombs. So that was distressing. But I had never seen the court have to surround itself with those 8-foot fences that are impossible to climb. And so I looked this up last night. The court only just in the last 2 weeks took those down. I'm hoping to go for this term. They're hearing an affirmative action case, something else I've written on. And so I've got in touch with my colleagues there, and I said, do you think I could get a seat? It's on Halloween by chance, to see the affirmative action case. And they said, we're not sure the court has still been closed to all public. And they're still not sure they're going to allow the public in for oral arguments. The justices are now meeting an oral argument in person in that beautiful courtroom. The press is allowed in and court employees, but the public has not been there now, in part because of COVID, but even when it opened up for itself, because of now Dobbs in part, and because of the release and because of the protest, it's not open to the public. That really hurts. So the last point then to raise is, fear not whatever your position is, in this sense that we talked about due process or substantive due process. Substantive due process, when it really started as an interpretation of the 14th Amendment, really was supporting business and supporting what was called the liberty of contract. Well, I challenge you to read the 14th Amendment and see if you can find the words liberty of contract there. So that was sort of a substantive due process element that conservatives on the court developed, going back into the Gilded Age at 1905 with this Lochner decision. And then when the court makes its famous switch in Time That Saved Nine, the WAG said, from the anti-New Deal majority, bare majority, to a pro-New Deal majority, then these rights were viewed as the rights, civil rights and liberties, and the rights of discrete and insular minorities. And so now we hear Justice Thomas in his concurrence say, well, we need to go back and rethink these rights. And what are they? The right to contraception, the right to sexual privacy and marital privacy, and the rights to have marriage equality. And so I just read this morning that Senator Schumer has said he thinks maybe in the next couple of weeks there's going to be enough votes in the Congress to overcome the filibuster. So all 50 Democrats plus 10 Republicans moving towards passing a law that would enshrine statutorily a right to marriage equality and interracial marriage. Now, Justice Thomas did not mention interracial marriage, I should say. I will leave you to decide why that might have been.
It is an equal protection case.
Exactly.
That's it. There's not substantive due process, right? Under 14th Amendment. So he should be safe, right?
It's both. So Naomi, could you weigh in on the legal pieces of this? And as Barbara just told us, only Justice Thomas said that other rights are in peril, so to speak. But what is the potential future of Lawrence and Obergefell as you look at this? Can the court avoid this?
Well, I don't have much to add to what Barbara just said. Justice Alito, in the opinion, several times tries to distinguish the right to, or several times distinguishes the right to an abortion from all of these other rights and says, I want to make it clear, this opinion is only dealing with the right to an abortion. And he says the difference here with the right to abortion versus all of these other rights is we are dealing with potential life or unborn life. And so he says that's what distinguishes the Roe Casey line of cases from, say, Griswold and Eisenstadt from the right to contraception. And so that's Justice Alito's majority opinion. Justice Thomas's concurrence only gets, right, Justice Thomas. And I guess Justice Thomas would have been the one who would have been assigning who could write the opinion. Mm-hmm. And so
because he's the most
senior.
Yeah. So, and the chief who usually gets the right to assign the opinion was not in the majority on that part of the opinion.
So that's also an interesting sign that it was only Justice Thomas who was calling into question, at least who was calling into question all of these other
and
rights.
He's been very clear about that all along in interviews and talking about his interpretation of the 14th. But I mean, he sort of has a pre-Civil War view of the Constitution.
Yeah, so in some ways, Justice Alito's opinion might be a way of seeing of protecting these other rights that do not involve Roe and Casey, simply because, I mean, just sort of reading the tea leaves of the court, it's Justice Thomas who writes that sole concurrence questioning all of this precedent. So that's one way of seeing this. The other way of seeing it is, as Barbara said, gee, where is liberty of contract written specifically in the 14th Amendment? Many of these other, I mean, the 14th Amendment does not mention a right to contraception, does not mention marital privacy. So there might be other ways of finding those rights, but the reasoning that the court used that the majority used in Dobbs could be used to question some of these other well-established rights.
And so we'll see.
We'll see.
Which leads us to, I want to bring in some questions. This is from the webinar, and I think it takes us on this trajectory here. So we have a webinar audience, and the question is, polarization on abortion seemed to rise beginning when Roe took abortion decisions away from the state legislatures, and each party then used SCOTUS appointments and the drama of confirmation hearings to whip up their bases. Do you agree? And I'll add a little bit. Naomi, you mentioned that Alito said that he was hoping not to have cases coming to the court anymore. Is there any hope of that actually happening, or how does this all play out?
Well, I'll say Justice Scalia used to say that as well. In his opinions and in his speaking engagements, he would say they get mail, stacks and stacks and bags of mail. And he would point out that the protesters would come. He happened to agree with most of them on Roe v. Wade Day, but he'd say, couldn't we just take this off our plate? It shouldn't even be at the Supreme Court. To Alito's point, and his point would be the states should make this decision. And I kept hearing on the day that Dobbs was handed down officially that it should be up to the people to decide. And the opposite position on that is, if there's a fundamental right of something, of anything, whether that's, some believe it's the right of contract, or it's a right to use contraception for married couples and unmarried couples, whatever it is, if somebody believes a right is so fundamental, do you want it to be left up to the people to decide? When the court, the federal judiciary, now some states have elected judiciaries. And in fact, my home state of Kentucky, they not only are elected, our state judges, they run out with a party label. But our founding fathers, in their wisdom, determined that they didn't want our members of the federal judiciary to be subject to elections and the whims and passions of the people. Now, they are, to the extent that they are selected, we know that, but they serve for good behavior according to Article 3 of the Constitution, which in effect means for life. So I doubt that this wish of just the late Justice Scalia and Justice Alito, who was sometimes called Scalito because he so similarly had views of Justice Scalia, I doubt they'll get their wish that this will take this off their plate, because as these cases and decisions and laws go into effect in states, people will be challenging them, as they have the right to do.
Naomi? Yeah, I think what you said, if it's a fundamental right, then the question is how can that fundamental right be restricted? I mean, the decision as to whether abortion is a fundamental right is something that the Supreme Court established in Roe, and then said Justice Alito, we were totally wrong. The court was totally wrong in Dobbs 49 years later. So the question of fundamental rights is rooted in the Constitution, but the time of Loving versus Virginia, just around a third of the states still had laws criminalizing the marriages at issue there. So if it's a fundamental right, sort of,
and that was a interracial marriage, as people sure know, who saw the movie Loving.
Yes.
Excellent.
But there's also, and again, just going back to this chart, in terms of political polarization, it's not immediately, I mean, at the time Roe was happening, right, there was also Watergate, there was the Vietnam War, there was a lot going on in the national consciousness. And so it's not actually until kind of later in the Reagan years that we start to see some of the political polarization that we now see on abortion. And then, in terms of coming up to the Supreme Court, you can see one state saying we protect doctors who perform abortions. In our state, that doctor flies to another state that doesn't, and service is served on that. I mean, you can just see the interest, just on one issue of interstate conflicts, you can see that the court might need to get involved. There are also a lot of privacy questions here in terms of Fourth Amendment searches, just a whole range of potential issues. Even just what is even under rational basis review, which the court sets out for abortion restrictions, there still rational basis doesn't necessarily mean that the statute will be upheld. There might still be some substantive review of the statutes themselves. So there are a lot of unanswered questions that even just returning the issue to the states sets up.
Yeah, I completely agree. And this takes us into a question that came from the audience, which is, how do we think about getting Roe back into the court? I think there's no issue with that. This is a lawyer employment decision. And we will be wrestling with many of these issues for a long time to come. And so on that note, any closing thoughts from each of you?
Well, I just will say, yes, back to my point about how people view the court, that if this continues to churn, and it will, as we see in our politics and in Supreme Court appointments and in presidential politics and congressional politics and state politics, what does that mean for the rule of law and settled law? Typically we like to see law settled, which is why the Supreme Court and most judiciaries hold to that stare decisis doctrine of let the decision stand. One is we don't want the law to change from day to day. We don't want to wake up each morning and say, I wonder what the law is today. And moreover, we want to respect those who interpret the law as our judiciary so that we know that this is what the law is, and that it was painful even for me just to read in Alito's opinion, not because of any disagreement I might even had with his opinion, but where he said that Roe was egregiously decided. You have to be very careful for, they call it fouling your own nest, for saying that your very institution that you are serving got it so wrong. It doesn't mean that the court has to hold to previous decisions. Look at Brown versus Board of Education, overturned its own precedent from 1896, the Plessy case. And so we want the court to overturn certain precedents, and many people wanted it to overturn Roe. But I just throw that out as, again, sort of a political science view of the court's legitimacy. It has to be careful about how and when it overturns and how it talks about a case that it's overturning and what it did originally.
Naomi?
I'll just conclude by saying what she said, and thank you. Thank you all. Thank you very much.
And thank you. There's much more to say, but not enough time to say it.
Right.
Thank you.